Good afternoon. I am Michael Foley, and I'm happy to welcome you to this CLE session. The call is coming from inside the house. We are so grateful for our sponsor, Perkins Coie, for their continued support of our chapter, especially during this past year's adjustments that we've had to make. Now I'd like to introduce her. Most of you probably already know her. She's a former board member, and she's been a partner with Perkins Coie for almost 2 years now. Her name is April Goff, and she focuses primarily on employee benefits, privacy, and labor and employment matters. So she's been a great friend of the board. I'd like to turn it over to her now. Thanks, April.
Thanks so much, Michael. And again, it's so nice to see a lot of friendly faces and get to see a lot of you today. I missed you guys a lot. So I'm going to talk to you about executive employment agreements, but also to be relevant for those of you who maybe don't have HR following up to you like Rudy does, or some other people I see in the office that I know that have the responsibilities for labor and employment. And here comes Michelle, and she's got it. I'm going to give you some tips at the end about yourself and things you can do for your own employment agreements and some asks you can make to make it relevant to all of you. So let's go through. The first question we're going to ask is, do you even really need an employment agreement? And the answer to that is really going to depend on what kind of employee you have. If it is an executive, yes, I want you to have an employment agreement. If it is a rank and file employee, chances are probably not. There's actually reasons not to have employment agreements. We'd rather use an offer of employment or a letter of employment for those individuals than you really would to have an actual executive employment agreement. Okay, 100,000%, not even 1,000%. If this individual is even possibly considered to be an independent contractor, the answer is no. We do not want an employment agreement because that is going to completely unwind any possible chance you have of actually calling them an independent contractor. And you will be surprised how many clients I've had that have some sort of agreement that is not an employment agreement that looks just like an employment agreement for independent contractors. If that's what you have, call me and I'll fix it, but we're not going to do that. That is a very, very, very bad practice. So the thing I'm going to say is, if you're going to have an agreement, it's just like anything else you're doing in writing. You need to follow what's actually in the agreement, but you also need to be careful, because if you don't have an agreement, the courts could say that you've established one based off of a pattern and practice of your behavior, sort of what you've done either as an employer or as the employee and how you've dealt with that. In the best case scenario, what you want to do is make sure that you actually have an agreement that delineates all of the major key points that you need to have. And I see some people taking notes. I apologize. I can email you a copy of the presentation, so you'll have this, but feel free to take notes. But if you need the presentation itself, let me know, and we're happy to shoot you a copy, or Susan can send you a copy if you don't want me to send it to you directly. I know when I was in-house, I didn't like outside attorneys sending me a bunch of junk, so I'm happy to send it to Susan, and she'd be happy to do it for you. So if you have that employment agreement, again, this is what we think of. You've got management, you got mid-tier management. This is really upper-level management and executives. A bonus question for you is to think about, do you need a separate proprietary information and inventions assignment agreement? If you're in a tech-heavy company, if you have something where there's a lot of intellectual property, designs, those kind of issues, you're probably going to want to have this. If you have it as a separate agreement, I always recommend, if you're doing an EA, an executive employment agreement, that you wrap it into the employment agreement, so that way it's all covered in one place and you're not constantly looking for various documents to match up, because you're only going to look for those things when there's actually a problem, and you want to make sure that it's all together in one. So we're going to go through a top 10 issues, and I'm not going to do it Letterman style. We're just going to go through and talk about the issues you really need to have in your agreements. First is term and renewal. Then we're going to talk about early termination and just termination in general. Compensation, benefits, and that's for the ERISA nerds like me. Duties and responsibilities, clawback provisions, tax considerations, equity awards, restrictive covenants, and then governing law and claim resolution. So just as a show of hands, just out of curiosity, how many of you actually have an employment agreement for yourself? A couple. Okay. Not many. And like I said, that's not uncommon, especially in the legal in-house community. It's not common to necessarily have one, but you can use these same things we're going to talk about to weave that into your own employment negotiations. And we'll talk about that as we go. So issue number one, term and termination and renewal. You would think this is the easiest thing in the world. Like, this is the most basic question. How long do we want to employ this person? Well, remember that Texas and a lot of other states are at-will employers. And if you put a term of employment in, that may negate your ability to have an at-will employment. So if you're not a labor and employment attorney, what is at-will employment? That means you can fire them for any reason or for no reason at all. And I put an asterisk there because we're not going to want to discriminate. We're not going to fire somebody for being Black or being female or being over age 40, but you can fire them because you don't like them, that they're not a good fit. The sky is blue. It doesn't matter. As long as it's not for a protected class reason, they can be gone for no reason. And a lot of times with no notice at all. Some states do require 2 weeks before you actually term somebody, but otherwise it's just based off of whatever you've negotiated at the outset. So if you have a promise to employ, you're going to have a promise to pay. And if you don't want to pay the money out, let's cut off the promise. So there's this weird sort of dynamic here where you have a balance between being commitment phobic. You don't want to promise the executive you're going to just hire them and keep them on indefinitely, but you want to keep them. And you want to make sure that if you've invested all this time, and search firms for executive level are expensive. You're looking at least, some executive search firms are 50% of their average annual wages. Some go all the way up to 2 years of average annual wages. So, and that's assuming that you have to engage a search firm. You've invested a lot of time, a lot of effort. You've probably gone through 5 or 6 rounds of interviews to get an executive on board. And that's a huge commitment from the company. So you don't want to have to do this every year. You don't want to have to do this every 6 months. You want the person to stay. And how you get them to stay and retain that talent really depends on this. Are we going to put a term on this? And if you are going to put a term on it, think of it like a promise ring, not an engagement ring, not a wedding ring. It's like a promise ring. You're going to put it on and you're going to say, okay, we think that this is going to work out. We're not really sure. We're going to put some parameters around it. And it's going to be longer than maybe a year. So maybe it's an engagement. Maybe it's a long engagement then, that analogy. But if it's getting to be, we need to keep thinking about this every 3 to 5 years. Like, is this actually going to work for us? So if a term is included, and I've actually seen this in an executive employment agreement for 20 years, there's something wrong, because you don't know where the company's going to be in 20 years, and you don't know where that person's going to be in 20 years. I've seen it with 5 years. Personally, I think 5 years is too long. I think 3 years is kind of your sweet spot, that you have 3 years and you renew for 1 year or 2 year, 3 year terms after that. So the other thing that I'm going to say is, if you have a term in there, you need to make it explicitly clear in the agreement that it is unless earlier terminated based off of the clauses inside. Think about also whether you want to have automatic renewal, or if you're going to want to renegotiate this at term. If there is a non-renewal, there's also usually a clause that you have to give 60 to 90 days notice. I've seen some executives that demand and have got 180 days notice. That is really unusual. The lowest that I see is usually typically 30 days, but 60 to 90, again, is sort of that sweet spot. And I'm feeling like I'm on my toes here because I see a lot of labor and employment attorneys in the audience. So feel free to chime in if you want to as we go. So that's the biggest issue, is really how long is this going to last? And then we get into a lot of the nitpicky stuff. And this is the one that the attorneys fight over more than anything else in an employment agreement. And that is the definition of cause, good reason, and what happens if you actually terminate the agreement. You need to think through a variety of situations. So using sort of the promise ring, engagement ring analysis, this is your premarital counseling advice. Make sure you actually sit down with your company and think about, yes, we're in love with this person now, but what if all hell breaks loose and this is not the right person for us anymore? How are we going to set ourselves up to land on our feet if this person is gone? If we either have to let them go or if they leave on their own? What are we going to do to make sure that we're able to continue on? So you're going to want to make sure that you cover situations for the termination for cause. That's when the company's done, made the decision that this executive has done something really bad and we would like them to leave immediately. Or the executive can say, you know what, actually, company, you've done something bad and this is not what I signed up for. You promised me this, and this has turned out to be a bill of goods that is not true, and I'm leaving because this is not what I was promised. Or something else. And that's where we get into this sort of amorphous situation where you terminate them without cause, or the executive has without good reason, or there's always this change of control issue as well. If it is a termination by the company for cause, that is the do not pass go, do not collect $200. That means that individual gets unpaid wages until the day they are terminated. If the state requires that you pay out vacation, you pay out vacation. Otherwise, you don't have to, and that's it. You don't have to pay out anything else except vested retirement benefits. And even those with equity, sometimes you can claw them back. And we'll talk about that in a little bit. If it's any other situation, it's going to depend on what your contract says. And that's where you really need to have these actually laid out. And it's, again, using the same analogy that I just thought up on the spot, which is impressive because I also have a concussion right now. So I apologize if I slur. So I promise I have not been drinking. I have a concussion. If you have this, you have to lay it out, and it's really like a premarital agreement. It's a prenup agreement. What's going to happen if this goes badly? And you're going to deal with things like severance. You're going to deal with possible acceleration of vesting, payout of accrued but unused vacation time, bonus, and is it going to be paid out at target? Is it going to be based out on actual performance? What are you going to do with that? And you have to be explicitly clear about what is a for-cause termination. And then if I asked you to give examples of what is a for-cause termination, you'd come up with great things like they committed a felony or they did this. But sometimes it's a little bit trickier than that. So we recently had a client that was dealing with a situation where they hired an executive. The executive on paper was great, absolutely great referrals from their previous employers. Everything was going well until the new employer found out, well, yeah, except that he'd been under investigation for sexual harassment at 2 of the last 3 employers. And it's kind of a known thing. Everyone knows that he's done this. Well, that's not for cause because it wasn't listed in the employment agreement as a for cause termination. He hadn't done anything bad yet at the new employer. And even though he had been under investigation and actually admitted to some of the things that he'd done, it wasn't at the current employer. And we didn't have a recourse under the employment agreement to say that this was a for cause termination. So what happens in that situation? He gets severance, he gets equity, he gets all this other stuff. We would have never hired the guy had we known about this previous information. You can build those protections in the agreement and protect your companies, but you have to have it in there or you can't follow back on it. So again, what is cause? It depends. And it depends on how good your attorney is that's actually drafting this. So if you're drafting it yourself, and again, I will email you this, I'm going to give you a little sample of what is for cause. And actually, I'll send it to you. I thought I put it in here. So causes, again, it's really going to depend, but it's going to be typically things like that individual has created a felony, he has insubordination, he's not following reasonable requests of the board. And we'll talk about the board in a few minutes as to who's actually, is like if it's a CEO, who they're actually referring to and actually reporting to. Now, on the contrary side, you've got the executive, and the executive's going to say, that's fine, that's good, I can promise you that. But I'm going to need some support too. And I need to know when I'm coming into this relationship, what I'm leaving with. And in that situation, they're going to ask for a good reason termination. And good reason means that the company has done something that has so fundamentally changed the nature of the relationship that they have good reason to leave. That is sort of our get out of jail free card, if you will. And good reason, and I'm not going to make you read this because it's tiny, but what it is basically it's a material change in their duties. Typically, it's utilized if there's been a reduction of the duties, if someone's been demoted, if they've been reassigned, if they've been sent to a different geographic area. And if you have nationwide companies, that may be something that you need to think about, whether you want to exclude that because you may reasonably ask them to relocate. And if you have this provision in there, they can step away and say simply, I'm not going to relocate. And by the way, I'd like all my equity and I'd like everything else paid out. So think through those issues. It really is based off of the type of business you have, what industry you're in. And again, this is not something we often lead with as the employer, but at the end of the day, you're probably going to end up with it. This is something that is reasonable for them to ask for. It's just going to be a matter of, from the company's perspective, you want this to be as narrow as possible. And of course, the executive wants to be like as possibly wide so they can fit anything into this good reason. So change of control. The first thing I'm going to tell you about change of control is try not to define it in your agreement. Chances are, if you're the type of company that has a change of control agreement, you want to incorporate that actually into the executive employment agreement itself. You don't want that to be defined differently. And the reason for that is different equity, different benefits trigger upon a change of control or a double trigger change of control. And if that differs from the definition that's in the executive employment agreement, that's going to be a problem. So I always like to refer that and attach it as an exhibit rather than actually putting the language in. If you're a smaller company and you don't have a change of control plan for your executives, you can put it in there. The typical kind of situations that we're dealing with here is, we're looking about acquisitions, business transactions. It's going to change the fundamental leadership and the direction of the company. Whether the incumbent board ceases to be the actual board, reorganizations, mergers, statutory share exchanges, sale or disposition of the assets or the stock of the company. And you can trigger that at different percentages. Some companies trigger it at 50, some at 80, some do it at 20%. Or approval of a liquidation. If the company is going to go bankrupt, sometimes you'll have this ability. What I really want you to note is it's actually more important to say what is not a change of control than what is a change of control. Because sometimes the language is a little bit amorphous on this. And if you specify, okay, if we sell up to 60% of the assets, that's not a change of control, that needs to be in the agreement. So if there's any doubt on it, really go drafting towards what's not a change of control. And again, if you have a kick plan, make sure that it mirrors that definition. All right, so early termination. Does she still get paid? So she's leaving early. She's decided, I'm done with this company. Do I still get paid? It depends. And it depends on what the termination, what type of termination. Remember, if it's a for cause termination, you get paid. You get paid whatever's accrued through payroll through the date of your termination, and that's it. You get paid vacation. If we're required to pay it out, that's it. Any retirement plans that's vested, you get that, and that's it. If it's not, it depends is it a for cause termination? Is it something else? And look at your agreement. Typically, you'll pay all compensation earned, any vested equity, unless a right of repurchase or a clawback exists, and all benefits and reimbursements due through the effective date of termination. There's a question though about, and this happens a lot with executives about, okay, well, they were on our group health plan. Can we continue them through COBRA through our group health plan? And that answer changes depending on whether you are an insured plan, which usually means you have less than 200-ish employees, 250, or if you're self-funded. Self-funded group health plan means that the assets are paid for, the claims are paid out of the assets of the company. And the reason for this is the IRS is sort of screwed up, and there are discrimination rules that are applicable to self-funded group health plans that are not applicable to insured plans. So if you're an insured plan, and then again, group health plans are only medical, dental, vision, healthcare FSAs. You can pay whatever you want for your executives. It doesn't matter if you discriminate. If you are self-funded, you are not going to pay them out COBRA. You are going to pay them a severance bonus that is roughly equal to the amount of their COBRA. And once you give them that amount, they can use it for whatever they want to spend it on. They don't actually have to enroll in COBRA. But that's the trick that you have to figure out if you're self-funded or insured. I will say that there is a special note too. You may not be aware of this. Anyone who is involuntarily terminated. So again, if it was a good cause termination, they would not be eligible for this. For anyone who is involuntarily terminated through September 30th of this year actually gets free COBRA through the federal government. The employer has to pay for it and they get it back as a credit on their employment taxes, but you can't charge them, even if you want to charge them, even if they have been fired for insubordination or they don't show up on time or whatever it is, you actually still have to give them free COBRA, up to including the 2% administrative charge. If it's something that is truly egregious, they don't have to be covered for this, but any other involuntary term does have to be. So you also want to make sure that you include a right of offset. You're going to want to make sure that you include a requirement for release, and that means that they sign it and they don't revoke it within the appropriate time period. And remember, your time periods are different if you're over age 40 versus under age 40. You're also going to make sure that you include a requirement, and we'll talk about this in a minute because God, do I have some stories on this one, to cooperate and return all company property when they actually leave. We'd be surprised the people that make so much money and what they walk out with when they leave and don't give back. So return of property. You want them to give you everything that they have that's related to the company. Records, designs, patents, business plans, Rolodexes, any type of information they have about the company, its current plans, its future plans, governmental audits, correspondence, memoranda, blah, 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 laptops, iPads, cell phones, if they're issued by the company. Problem is, how many of your executives have a personal phone that they use for both? A lot. And what you need to make sure is in this agreement is the ability to actually go to that executive, get on that phone, make it, mirror it, review it to see, because chances are, if you're going to have a lit hold, who is it going to impact? It's going to impact people who made key decisions. And that's going to be a lot of your executive team. they need to be able to make sure that they do this and do it on a timely basis. So within 48 hours. I will not name the company, but I was involved in the negotiation of an executive departure where the executive left with the company jet and was in the Bahamas. And the termination of employment was on a Friday and was not scheduled to return until Monday. And the company jet is now sitting in the Bahamas so he and his wife could have a little soiree for her birthday. And that's company asset now. And the aviation team, the employees of the company, are also now in the Bahamas. And what do you do? Well, what I wanted to do was bring them back, and he can fly back coach. That's not my problem anymore. He's no longer an employee. You need to specify that. You know, what's going to happen? How quickly do you have to actually return company property? Keys. For smaller companies, you would be surprised how many times we have to get buildings rekeyed because people don't send stuff back, or executive, you know, the executive suite, special keys there, making sure you get those information back. And I say include within 48 hours. I say within 24 hours, really. I mean, you can ask for that. 48 hours is probably more reasonable. And they're going to balk. People will say, I don't want you looking at my iPad. You don't want to see the pictures on there. No, actually, I need to see what's there. Did you take pictures of our company IT? Did you take pictures of, things that are protected from us? So the next issue we'll talk about is comp. Again, this is full comp, not just salary, not base salary. So that's compensation, bonus, equity, and you need to be very, very clear about a lot of things. How is it paid? When is it paid? Is it every month? Is it every 2 weeks? Is it on Fridays? Is there incentive comp? If you have an incentive compensation or bonus plan available to your rank and file employees, does this individual eligible for it? Or do they have a different equity or a different comp plan that's just for the executives? Bonus, again, is it discretionary or objective targets? And if it's objective, that's fine. What are those targets? And when are they going to be notified of those targets? If it's discretionary, who makes the determination? Is it shareholders? Is it the comp committee? Is it the board of directors, the chair of the board? Who determines those targets and performances? The other thing to look at is automatic increases. You would be shocked at how many people go ahead and guarantee like a 6% increase year over year. Well, the company may be doing really bad. Don't put that in there. You keep it much lower. That maybe a cost of living increase, but that's all we're going to assign to. And then at the discretion of the board, we will up you to a different level. So that's going to be the most of your comp. And I know a lot of people in this room know me and know that I'm secretly an ERISA attorney. Get benefits counsel involved, especially if there's equity in. Labor and employment attorneys are my favorite people in the world. I like to play one on TV, and I do a lot of labor and employment work. But for benefits, you really need benefits counsel. And the reason for that is this is so specialized, especially benefits counsel that deals with executive employment agreements and 409 Cap A, which I will say is the only thing that has ever made me cry in my legal career is 409 Cap A. It is a mess. It is a hot mess, and it is something that will unwind a lot of executive employment agreements if they're not set up properly. And the reason it does that, and we'll talk about it in a little while, it's a 20% tax on the executive, not on the company. But that executive is going to sue you, and he's not going to sue you just for the 20%. He's going to sue you for his attorney's fees. He's going to sue you for his allocation of his auditor, of his financial statements, of everything else. And it's just a disaster. And it's easily fixable if you have somebody who knows what they're doing on this. So the other thing about benefits is you need to make sure you can actually provide the benefit you're promising. ERISA requires that you follow the plan terms. You can't make exceptions to plan terms. It is very just a cut and dry. If it's eligible under the plan, that's fine. So you need to make sure that enrollment periods, eligibility for dependents, those kind of things are actually allowable under your plan. If they're not, figure it out outside. Give them additional salary and let them buy the benefit on their own. But don't promise something that you can't actually give. You can also create a top hat plan. And yes, that is exactly what it sounds like. I mean, think about like Mr. Moneybags with the top hat and the monocle. You can create a retirement plan for upper level key management that's different than the retirement plan that exists for all other companies. And you don't have the non-discrimination issues of making sure that everyone gets the same contribution. So absolutely, that's possible. Those are getting to be less and less common because of issues, especially for publicly traded companies, which require disclosures about the executives. But that may be something you want to look at. Other things that you can build in that you can give as a gimme, expenses reimbursements for company travel. If you have that in there, Does it have to be approved company travel? Can it be just any travel that they have? What class of travel does it, are you going to allow them to fly business, to fly first? Is it going to be just at coach? Are there documentation requirements? Do they have to actually submit to whatever the employee sort of policies and procedures are for everybody? Class of car. Are they getting the, completely pimped out, absolutely top of the line car? Or are they going to get a sedan? Making sure that you have that in there is really helpful. Security. So I have had the situation with an executive before who had 3 homes. He had security at all times in 3 homes. He had a security guard that followed him everywhere between these 3 homes. The company paid for all of this because it was deemed to be something that was necessary for the company. But did they really need it for all 3 homes 24 hours a day if he wasn't actually there? Well, they promised it in the agreement, so that's what they got. Think about also executive physicals. A lot of times we offer these for executives. That's usually like $5,000 or $10,000 a year for them to be able to go to like Cooper Clinic or go somewhere else. Because of a change in the law, because of the Patient Protection and Affordable Care Act, those can no longer be standalone plans. If you have executive executive physicals, those have to be integrated with an underlying group health plan. So that executive either needs to be in your plan or another employer's plan, or that is going to be a taxable benefit to them. So more to come on that. If you need questions about that, I'm happy to answer those. Vacation, how many days of vacation did they get a year? Does it carry over? If you're publicly traded, remember all of these perks end up getting reported in their proxy in the CDNA. And that is something that you need to have a good story about if you're publicly traded, about why they're getting these benefits and why you're letting them fly first class every day of the year and on the private jet, and why you have 3 private jets and 3 private cars for them and all of their families. You have to have a story behind it. Doesn't mean you can't do it, but you have to be a good storyteller. And that's something that you need to think about from a business perspective is, do we really need this? White glove relocation. You can come in and have somebody completely relocated everything, where they just leave one house one day and come into the next and everything's unpacked and put away and everything is completely done. That's very common for executives. Private jet utilization. Okay, so I lied. There's 2 things that have made me cry in my career. The second was working for a company that had 3 private jets and trying to figure out the tax treatment if someone was using it for personal use versus company use. So that actually, there's 2 things that have made me cry. It's complicated, but you need to specialize. Can they use the private jet for personal use? If so, what percentage of the time can it be used for personal use? Are you going to require that they use it because it's safer than using it for commercial? Liability insurance and indemnification. If they've done something, and being a CEO, being a CFO, is the company going to indemnify them for that? So duties and responsibilities. A lot of times I see language in here like consistent with an employee at her level. Well, you know what? That doesn't mean anything. That doesn't help. Don't put that in there. Act like a CEO. Well, CEOs act very differently. Again, that doesn't help. What you want to do is put a requirement in there that they are going to devote their full business time and attention, or their entire productive time, ability, and attention to doing the duties that are delegated by the board or other duties as assigned. So yeah, there may be some things that typically a CFO will do, but you know what? Maybe if the company's in crisis, we need the CFO to expand and do a little bit more. If it's something that's reasonably requested, they should be able to do that. And this is a tax issue, but where are those duties going to be carried out? You need to specify if it's going to be at headquarters or as assigned, because that becomes a payroll tax issue. You'll also want to make sure you include a provision regarding performance, that it's reasonable and appropriate manner in a company, where the clients, with the company's policies and applicable law. You want to make sure you exclude other employment. I've had executives before who's a CEO of a very large company that also has another job, or also writes books, or also does something else. And you're like, well, you can't really be a CEO because you're doing all this other stuff. And it's like, well, you didn't tell me I couldn't. And right, if you don't tell them that you can't, they can. So you have to put that into the agreement and make it explicitly clear. You're going to want to define, limit, and restrict other board of directors or volunteer work, leadership opportunities. That doesn't mean that they can't do it. It just means that they have to disclose it to the board, and the board has to approve that it's reasonable. And the reason for that is sometimes people get so passionate about what they really care about that they will devote all of their time and attention to their nonprofit situation and to all of the things that are very worthy causes, childhood cancer, all kinds of issues like that. And you don't want to tell them no, but they're taking away materially from the production of the company. So you have to balance that. And it's not that they can't do it. It's just that it has to be appropriate and reasonable. You also can give them de minimis time for managing their own personal investments. That does take time. If you're managing your own stock portfolio or real estate investments, but it shouldn't be all of your time. They shouldn't be, day trading all day when they're trying to do company business. And require this on an annual disclosure. So it's not just upon employment, but it's every year thereafter. So clawback, I really want you to think about including these into your agreements. Whether it's a signing bonus, retention, relocation, if the executive leaves before a specific point in time, that you're going to get some of that money back. And it may be all of it, it may be a pro rata portion, but they shouldn't be able to walk away with everything, their pockets stuffed full of company cash because they decided to leave early. So you can also do this with equity. You can pull it back if they've breached, but typically it's only if they've breached a covenant, which we'll talk about soon. So expert advice here, again, 409 Cap A, you really want to make sure that you have an executive employment agreement reviewed, not just by Labor and Employment Council, but by someone who specializes in 409 Cap A. It is the most miserable piece of the tax code that has ever existed. And I say that as someone who's read the entire tax code and actually sleep with it next to my bed. It's bad. So what does it really mean? So deferred compensation is money that you earn in one year that's actually paid out in a later year. Doesn't matter which year it is. It's just deferred. It's not going to happen this year. And you can allow it to accrue tax-free sort of if it falls under one of these different exceptions. And you'll hear a lot of attorneys say, well, that's not subject to 409A. That's not really what we're really worried about. The issue is or it falls within 409A. Most of the time, we don't actually want it to fall within 409A. We want it to fall within an exception. And there are exceptions. So if you're a key employee and you're paid out in a lump sum, typically, if you do it in a lump sum versus installments, that may be an issue. If you're a key employee, a lot of times you have to defer that for 6 months after you've actually left a company. You don't get it right away. You have to actually wait for your deferred comp until you've been out of the company for 6 months. There are exceptions for death. There are exceptions for disability. And you need to define what disability is. Is it just the inability to actually do your day-to-day job duties? Is it based off of what your short-term disability carrier says? Is it based off of what your disability plan says? The other issues you want to look at is stuff like reimbursements. Reimbursements can be considered to be deferred comp. So if you have all these reimbursements, and if you're someone like me who forgets to turn her receipts in until way later, they may cross plan years. And then all of a sudden I've got all these, all this money coming back to me at one time, and that's deferred comp, but it's an exception because it's a reimbursement of an amount that was already owed to me. We really want to set this up from a tax perspective that you're getting paid back things that fall outside of 409A. It's not that it falls in 409A, it's one of the delineated exceptions to it. And again, like I said, it's a mess. Just get counsel on this, because even benefits counsel don't really like to deal with it. And you need to have someone who has really expertise in that. Withholding. This is another issue you really need to think about from a tax perspective, both from the company and from the executive. So I always recommend that you include whatever the executive, where he's supposed to or she is supposed to work, and where his or her address is. Because you're establishing tax domicile with that, which means which state income tax are you going to be withholding for? And who are you going to be reporting for on behalf of the executive? And the problem with this is a lot of times executives have more than one house. They got a place in Vail, they got a place here, they got a place in Miami. Which is their actual permanent home? And that's the address you want to actually have on there. But I caution you that the domicile aspects, if they have multiple homes, if you're not actually operating as a company in those states, that can actually be a problem for you, because now suddenly you're conducting company business in an area where you're not licensed to do business in the state. And that's a federal tax issue and a state tax issue. And you really want to get tax counsel on that. If you're allowing them to do, like, especially now with the pandemic, people are living a lot of different places that aren't their actual home. Like, hey, I'm just going to go hang out for a couple of weeks in the mountains or a couple of months in the mountains. Well, now you're suddenly doing business as a company in a state that you're not licensed to do business in, and potentially have to file for the ability to be recognized by the state as doing business there, and submitting sales and use tax and other things in that state. So be careful with that. That is going to be a huge sort of fallout from the pandemic that we did not expect, and that we sort of didn't think through, and the government certainly has not caught up with. And a lot of companies are now starting to get notifications that they have violated state tax law primarily by having an employee in a state and conducting business in that state without being licensed. So you can get that from the get-go about, making them disclose which states they're going to be in. And again, that has more issues for the company, but 409A is really for the executive. And again, that's a 20% tax on the value of the deferred comp, which the value of equity payouts and those kind of things for some of these individuals can be very, very high. And if they get tapped with the 20%, they're not going to do it themselves. They're going to come to you and want reimbursement for it. So equity awards, and I could talk to you about 15 years on these topics, but I'm not going to because it bores a lot of people. But there's a variety of different options that you can do. Both are actual options, stock options, which can be either qualified or non-qualified, depending on how the value of them, what kind of company you have. And when I say qualified, that means for tax purposes. That means that they don't have to necessarily recognize some of the tax implications there. You can have stock appreciation rights, restricted stock, RSUs or restricted stock units, which is sort of basically marries along with the value of the stock, but it's not an actual stock, or they get to return the stock back. A lot of companies now, instead of giving actual equity, are giving performance cash, which means that we tie it similarly to performance the way we would for a grant of equity, but we're not going to give you actual equity. We'll give you cash instead. And that's particularly true within the last year when the market has been so volatile and company stock has been up and down, up and down. They're like, hey, we can't guarantee that the value is going to actually be what we hoped it will be, so we'll give you cash instead. What I will encourage you is don't replicate what's in your various long-term incentive plans, whatever is in your stock plans. Don't, because those plans get amended, they change. So what you're going to do instead is refer to grants, refer to the plans themselves and attach them again. So an employment agreement may be 8 or 9 pages long, and then you've got, all these other, the Inventions agreement, you've got the plans, everything else sort of packaged together as one document rather than replicating language. I want you to be especially careful here about restrictive covenants. So a lot of times equity agreements will have in there restrictive covenants that will claw back. So if you breach the duty of confidentiality, of non-competition, of other things, we're going to take your equity back. Well, the problem is that the company, if the executive's in a state like California, you can't enforce a non-competition restrictive covenant for most of the case. And that means you can't claw back their equity. And it's something that you need to make sure that whatever is in this employment agreement is also what's in the equity grants and also what's in the plan. And it needs to be in all 3 places. And it needs to be exactly the same with respect to those restrictive covenants. And we'll talk about those, I think, next. But it cannot change. Even what the definition of a competitor is, completely undermine your ability to actually claw this back. So be careful with that. So restrictive covenants, what are those? Well, that's a promise from the executive that I'm going to do something, even if I leave, that's going to protect the company. And that's where you're going to give me all this cash, and I'm going to be just rolling around in it. So the biggest thing is, and this is something that typically we tie these to the length of a severance period. So if an executive leaves and they have a 1-year severance period, they usually marry up to we'll promise this for 12 months. It's not uncommon to go as far as 24 months for high-level executives, especially like for publicly traded companies. I wouldn't say it's even worth it to go less than 6 months. So you're really looking at, are you doing 1 year or 2 years? Non-disclosure confidential information, though, that's a forever. They can't disclose anything that they've learned about the company that was confidential in nature at any time. Non-competition, on this one, you've got to be rational. You can't say you're never going to work for another company anywhere in the world ever again. Well, no court is going to uphold that. It needs to be looking truly, who are your real competitors? And you can't just say, okay, I'm in retail. All retailers are my competitors. No, you sell women's shoe wear. Who are your competitors that are selling women's shoe wear? Make it, or similar products. It's usually typically enforceable if there's a small number of named competitors. I always use a rule of less than 8. If you have less than 8 competitors on there, it's usually a good idea. If you get to 10, it's too many. Courts freak out at 10. So just keep it less than 8 and you're good. Keep the duties same or similar to what they were currently doing. You can't say that they will never have any job doing anything for the rest of time. Is they're not going to do the exact same job, the exact same responsibilities, or similar to those responsibilities for one of your key competitors. Some jurisdictions just won't enforce them. Good luck in California trying to get a non-competition provision in place. And in Texas, you can't have a standalone non-compete which is our trick is to put it in your NDA and your non-disclosure agreement. Make it where there's some additional, you give them something else, like a little severance or something else that's just a bit different in the NDA, and then you can get it in. It's a really manipulative way to do it. I don't like lawyering that way, but in Texas, that's what we're really required to do. Non-solicitation. This applies not only to employees who they're working with. You get a great finance team, the CFO leaves and takes your entire finance team with him. Unless there is a provision in there that says that non-solicitation, you can't ask the employees to leave with you. And that you can also have for solicitation, which remember back in torts in law school, we talked about interference with business relations. That's really what this is with the customers is your vendors, is they're not going to say, hey, I know you work with XYZ company and I used to work there, but we have a much better company or we have a new thing that I'm doing now. Why don't you leave XYZ company and come provide that same product to us at a better price or the same price and take the business away from the old company? That's what we're really talking about is solicitation of customers, of your business partners, your vendors, suppliers. You need to have all of that delineated in the agreement. Non-disparagement. You can lead with just the company, but really it's going to end up being mutual because the executive is going to say, that's fine. I'm happy not to say anything bad about you, but I want you to promise that for me too. And you have to think about that too from an employment perspective. If someone's calling for references, that means you're going to be limited to what you can say about that individual if they've left on bad terms. And you may not be able to give them the full story. But what I've seen is a lot of times you can say a lot by what you don't say. And there is a way to handle that. It's just very judicious on how you say it. Length of the covenants, again, you typically want to marry that to the severance period, except confidentiality, which is forever and ever, amen. They're generally enforceable if it's necessary to protect the employer's current relationships with customers, trade secrets, confidential information, and they're reasonable in duration, geographic scope, and scope of prescribed activities. So governing law, usually the default is wherever the company is headquartered. However, I will say that a lot of states actually don't care what you say in there. It's going to be wherever the employee lives. So be careful with that if you have employees in California. Venue, you want to be very specific down to the county that you actually want to have courts in. Otherwise, you're going to be traipsing all over the world going to claims. And be practical with your claim resolution. Litigation may not be the best option. Think about binding arbitration or mediation, especially if you're going to like jams or something else where you have labor and employment specified mediators or arbitrators that are trained in this area. Because with court, you're getting the luck of the draw as to whatever your judge is, who may not have a background or experience. Maybe they are great at riparian rights or some other random thing, but they don't know a lot about labor and employment. And you can have some combination of that, but you need to have it specified. The catch-all terms, this is your general boilerplate language at the end, but you need to make sure it's in there. About prior agreements, assignment, binding effects, complete agreements, notice, how do you give notice? Who does it go to? Typically what we do is now, of course, a lot of people aren't actually in the office. So email notice, but you have to say that a follow-up notice in writing is actually being provided at the same time. Severability, construction, yada, yada, yada. All this stuff. It's in every commercial contract you've ever written. That doesn't really change based off of the fact that it's an employment agreement, but it needs to be in there. So we're almost at time. In the last sort of 5 minutes, what I want to talk about is what you can do and take this for those of you who don't do HR, who don't do labor and employment work, and how can you sort of translate this to your own job and your own thing. The first thing is, the statement or sort of saying to know your worth and then add tax. You have a value as an in-house attorney. However, when I say then add tax, be reasonable. We're talking like, small amount of sales tax here, not VAT like in European setting, okay? This is something where you have to be reasonable, but you have to know the market. And the way that you know the market is by benchmarking. So use the surveys that are available to you. And that's something, so also when you're setting salary for executives, use salary surveys that are available to you for executives. Use Korn Ferry, use some other company like that actually will help you establish what is appropriate in this jurisdiction for this type of executive. But like Robert Half, Barker Gilmore, ACC, they all have annual in-house salary reports. Look at them and talk about them with the other people on your team. And talk about like, where are we compared to market? And is this something that's reasonable? And I know it's very taboo to talk about pay, but you're not ever going to get that information unless you start talking about it with each other. And the reason companies have made it taboo for you to talk about is because they don't want to pay you anymore. And if you don't talk about it, they don't have to pay you anything. And everyone's just suspicious, like, well, so-and-so makes more than me. No, talk about it. Be more open and free about it and see what's equitable in your, and if you don't want to, then that's just not a data point that you'll have in your negotiations. The biggest thing you can do to your general counsel or to your board is to demonstrate value. What have you done that has brought value to the company, that has made it where it's better to have you sitting in a seat in the office versus someone else, versus hiring outside counsel? What expertise do you have? What passion, what leadership do you have that's different from any other person that's in this job? And that's how you get the ability for upward mobility and increased pay. The other thing is, think about things like, especially now, do you want additional time off work? Do you want, maybe you're working from home, maybe you're indefinitely working from home. Do you want other benefits now? Do you want them to help pay for non-utilization of your house because now you've got a home office? Do you want them to help pay for part of your maid service or help you with childcare because now you're dealing with the kids at home after school while you're working from the office, which is now your master bedroom? Think about, do you want them to pay for a percentage of the utilities? Now you had to upgrade your DSL so you could have fast enough Wi-Fi so you didn't crash every Zoom meeting you're in. Maybe the employer should pay for part of that. Making that case, but just like anything else in your business teams, if they came to you with a proposition and they didn't have the backup and they didn't have the business case for it, you'd laugh and say, that's nice. We're not going to approve that. You've got to make the business case for yourself. Think about other things, CLEs, professional dues. What do you need to do that can make you a more valuable member of the team? What can they invest in you so you invest more in the company, and making that case? At the end of the day, ask for equity. Equity is often much cheaper from a company's perspective than cash is. A lot of times it's difficult to pay out more cash, especially base salary. Ask for a higher bonus, because base salary, you're locked in. Usually you have year over year increases. A lot of times companies are hesitant to put money in base, but they'll give you, if you've had a really good year, a better bonus, or they'll give you more equity. And you can make a case for those sometimes better than you can an actual base salary. Remember that it all is comp. At the end of the day, it's all going in your paycheck. It's just a matter of what are you actually negotiating for. Another thing that's, I would say, when I was in-house, I did not have a guaranteed outside counsel budget. It drove me insane because I couldn't get approval to get some stuff done that I just didn't have the capacity to do, or it wasn't in my wheelhouse. And a lot of times, as you know, in-house, we have what I call door law, where it's like whatever comes in the door, suddenly I'm going to figure that out. So I did aviation law. I did, labor and employment in California. I did a bunch of other stuff that I never would have touched in a million years because we didn't have a budget for it. One of the things you can actually negotiate, and this is a quality of life issue, it doesn't increase your pay, but a guaranteed outside counsel budget that says, okay, I know that this is an area that I struggle with. I'm not going to mess up the company's bottom dollar on this, but if you guarantee me X dollars, I can get a appropriate resource on that can help me and make it easier for me to do my job and do a better job at my job. So I think that's basically all I have for you. What questions do you have? I know we've got like 5-10 minutes left. Anybody? I know I've got people in here who talk, so don't be shy.
Yeah. Any questions from the floor?
All right, Michelle, what you got?
I know that most of what you have is based on your executive compensation agreements. A lot of companies have obviously these agreements for sales folks. Is there anything specific that is different that you should focus on if it's not your high level executive, but you have a lot of employment agreements with your sales folks because of the confidentiality and the
So the question, if everyone couldn't hear it, was, what would be different if you're doing this, not necessarily for high level execs, but for sales team members? Making sure that it's explicitly clear, and this is just off the top of my head, what geographic region or what type of, if it's a size, it depends on what your company is doing, whether it's geographic region. Some companies do sales based off of the size of the contract. Who has responsibility for that? Any revenue sharing based off of whether they secure that deal. And if that revenue sharing actually extends beyond the length of their employment. Sometimes an employer will actually continue to pay in arrears and will say, we'll pay you up to 5 years if you bring this big contract in, but then you leave and suddenly you will end up staying in a company you don't want to work for anymore because you want that 5-year payout of this giant contract you have in. So sometimes you can actually put in a provision that says, after you leave, you'll get 50% instead of being the full amount, or you'll get a certain percentage. Who they report to, That can be really problematic with sales teams, especially if you have geographic VPs and RVPs, regional VPs, who they report to, when you can ask them to relocate. Because that's something that does happen a lot with sales teams is suddenly you're in Cincinnati, Ohio, and then you're in Los Angeles. And what is the company going to do to help sort of integrate you into your new community? The other thing is it really depends. I'm assuming that these are exempt employees. If they're not, any travel time, what's going to be compensated, how they get compensated for travel, how they actually, and you could just reference to whatever the company's general travel policy and reimbursement policy is, but you want to make sure that they are actually timely submitting receipts and are actually following those precautions, and that any deviation from that has to be at like a regional vice president level or above. So those are just a few random thoughts off the top of my head. Yep.
Hey, April, we have a question online.
Okay.
The question is, how do you contract for allegations or accusations of bad conduct that you might not even think of up front? Do you put them in the employment agreement? That for cause includes if an executive is accused of multiple times of bad acts at prior companies, or if he or she kicks a dog, or if he or she is known to drink too much alcohol or something else. Do you put it in a morals clause, or how do you draft for the unknown things?
Thanks, Alvin. So this is actually it's a good question. That's the issue that I talked about before. And so I've had two issues that I've recently dealt with this issue. One is the one that had the multiple sexual harassment issues that had been investigated at prior companies but weren't disclosed by the prior employers. When they asked for the referral, they got a glowing review. You would put that into some sort of morality clause. I've also had a situation recently with an executive who had a known cocaine problem and was high all the time at work, and the company could not function because he would not show up sober. This is something that you really need to have the morality clause in there. And I kind of laughed. There's another employment agreement that I put in there. What is morality for your company really depends on the facts and circumstances of your company. I've dealt with a large conglomeration of Christian schools, and they have very strict biblical references as to what is acceptable and not acceptable for their employment. And if you depart from that, that is a fireable for cause termination, which obviously would not be the case in most other employers. But you as the employer have the ability to put that in there. I would encourage you to also allow that I wouldn't say that you even have to have multiple violations from a previous, but just if there are credible allegations. And that means that you as the employer will have to investigate and deem what is credible. You don't want to fire someone if they've been accused of something they didn't actually do. So if it's not credible, that's not something you want to treat as a for cause termination. But if there are credible claims there, you want to be able to investigate those, even if it happened prior to termination, because it could impact the goodwill of your company. Okay. Anything else?
Thank you. Any other questions from the floor? Okay, April, any final thoughts?
The only other thought is, a lot of you, this is not rocket science, but you need to be really careful and rely on the experience of people who have done this before and who have seen the war stories about what can go wrong. I would encourage you to, whether you're talking to the labor and employment attorneys inside, whether you're talking to outside counsel, don't just pull something off the shelf or something off of Google and just use that. Think through how this actually applies to your facts and circumstances in your industry, because things that are applicable in a public company may not be for a private company. For different types of equity, different types of triggers, always consult an expert, whether it's internal or external, about your plans and making sure you're not promising something that you can't actually provide, because then you end up being on the hook for paying for essentially extra cash outside the plan that you couldn't have otherwise covered. Otherwise, that's all I have. Thank you so much. It was great to see a lot of you, and I appreciate being here.